This is, I think, the fourth year that we have run a panel on DPAs and something, DPAs and their independence, DPAs and their cooperation with each other. And this year is DPAs and technology, in which what we're trying to do is to find out what DPAs, what their understanding, how they understand technologies, whether they have sufficient expertise within their organizations to meet the regulatory challenges that face them, face all of us. I won't describe what the overall questions are. You can see them up on the screen, and also on page 30 of your booklet, you can read more about the panel and the description of the panel. But let me first introduce very briefly our panelists. On my immediate right is Dr. John Borking, who is the director of Borking Consultancy in Wassenaar in the Netherlands. He's also the counsel on privacy by design for CMS Law Tax. He formerly was the vice president of the Dutch Data Protection Authority in The Hague and worked in rank Xerox. He's a certified privacy law expert for Europrize in Bonn and an expert member of the advisory board. Then there's Marit Hansen, there. Marit is the privacy commissioner from Schleswig-Holstein, and before that she was a deputy commissioner and in charge of privacy technology projects within the ULD. She has a diploma in computer science and has been working on privacy and security aspects with a focus on privacy by design. Then there is Amandine Jambert, is an IT expert for the CNIL in France, French Data Protection Authority. She's involved in technical negotiations about privacy at the European and international level. And she has a PhD in cryptography on cryptographic tools for users' content and privacy protection. And last to be mentioned is Achim Klabunde, who is the head of the IT policy sector of the EDPS. Before that, he was a policy officer in the European Commission in DG Justice, and then before that in DG INFSO, which is now Connect, in charge of privacy and trust policy for electronic communications. He has a master's degree in computer science and communications from Bonn University and has worked in data management, network planning, data protection, and IT security. So you can see that all the panelists have some kind of technical IT, computer science background, and that leads us into our panel today. And what we are going to do, and I should hand over to Yvonne now to describe what we're doing, because we conducted a survey, as you can see in the booklet, a survey, and this panel is going to reveal the findings of the survey that we conducted and then ask the panelists to respond to questions about that survey. So can I hand over to Yvonne just now?
Thank you, Charles. There will be 7 issues we would like to discuss in this panel, and in each case I will show you a few slides, the main findings of the survey. But we are not going to present the survey itself. The survey will serve as a framework for the discussion. And then after the slides, we will have a discussion on this specific issue, then another few slides, discussion, and so on, 7 times if we have time enough. And at the end, there will be a questions and answers sessions, and we also have a special guest who will have to, who would like to intervene from the audience. For those of you who are not familiar with the CPDP slang, we'll be using 2 acronyms all the time. One is DPA, evidently it's Data Protection Authorities. Information commissioners, privacy commissioners, commissions, authorities, all kinds of independent supervisory institutions. That's DPA in our understanding. The other is ICT, also well known, for information and communication technologies. That's too long. Sometimes we use IT, information technology. So, and And I think that's the most important thing. We sometimes, I myself, I would invite the audience for a quick vote on a simple, maybe oversimplified question. So a few words about the survey itself. We means Charles, Raab, and myself, we contacted all the DPAs of the member states of the EU, plus from the countries of the European Economic Area, like Norway, for example, plus Switzerland, which has a special status, as you know, and the European Data Protection Supervisor, the EDPS, whose representative is sitting with us. All in all, it was 32 national DPAs. Amandine, for example, is from a national DPA, and 46 sub-national DPAs. Marit is from a sub-national DPA, Schleswig-Holstein, a state of federal Germany. And the size of these DPAs were really very different. The smallest DPA consisted of one single person, and the largest ones have a staff of 100 or over 100 members. The response rate was satisfactory, not perfect, but satisfactory. As you see here, and we can also see, and thanks to the technical managers, we have two large screens here. So we don't need to turn, especially the panelists don't need to turn their neck to the screen. So you can see that almost 80% of the national DPS responded to our questions, and our questions were answered mostly by the competent leaders. One thing is important to clarify at the very beginning. We are completely aware that this is not a statistical sample in the strict sense of the word. A small sample, very diverse organizations. So please don't expect sophisticated multivariate analysis on the data. Instead, as you see, we applied a mixture of simple quantitative and qualitative methods. These are countries of Europe which we contacted. The blue countries. The stripes means that there are sub-national DPAs in those countries, Swiss cantons, Germany, Spain. May I ask the audience, who is from the audience, from countries, from the blue countries on the map? Please raise your hands. Almost everybody. Okay, the counterproof. Who came from countries other than the blue countries on the map? Just a few, yes. Thank you very much. Abstained? Anyone? Okay, I know life is sometimes too complicated to squeeze into strict categories. But anyhow, the majority of you are from European countries. Okay, and these are the countries which responded to our questions as of the 31st of December. So those countries which remained blue, that means that we didn't get an answer from them. We received two belated responses, one from the EDPS, thank you, Achim, and one from Romania. So in the next round, we will include these data also in the analysis, but up till now, we have only the green countries in our sample. First issue, the existing expertise of the DPAs as they see it. So the first question was to the DPAs, how would you rank the existing expertise of European DPAs in general? And this is the result. So in short, the respondents, the majority of the respondents think that the technical, the ICT expertise on internet, data mining, all kinds of modern information technology of the data protection authorities are higher than medium. Next question was, how would you rank your own organization? Even higher, as you can think. The green columns show the own institutions ranking. And if you take a look at this so-called scattered graph, it's not very complicated. It's easy to understand. It's very decorative. It reminds me to our rooms in Meta Bloom, the wall paintings. Each and every DPAs are represented on this graph with two dots, red and the green dot. The red dot means the score they gave to the general expertise of European DPAs, and the green one, which they gave to themselves. As you see that in the great majority of the cases, they rank their own expertise much higher than the average, which is a logical nonsense, anyhow. But in general, one has an impression that they tend to overestimate their expertise. So first questions to the panel. I will not read it. May I turn directly to Marit? You are an active privacy commissioner with an exceptionally high level of IT expertise. We all know it. But the survey was not about individuals. It was about organizations. So how would you rank this result and, in general, the situation?
I think those who have answered probably are more interested in technology, and otherwise they would have waived your questionnaire. It's not that logical that CNIL has not answered, but still, because I believe there is a lot of technical expertise, but I don't think that it's already the explanation everybody overestimates their own organization. And if you have, and the rest. So the first picture was, most are in the middle. So in general, it could be worse, it could be better, or it should be better if we believe that that technology is very important. But I think those who have answered have more interest in answering, and you also pointed out that some IT departments answered. And this may also be an explanation because obviously they have more
Yes,
more
there were only a few IT departments, but let me turn to Achim. We all know that the EDPS is not the boss of the national DPAs or the subnational DPAs, but you are regarded as a kind of source of guidance. So from your position, how would you judge this situation, the existing expertise, and secondly, how they see themselves, the DPAs?
Well, as regards the self-assessment and the general assessment, I would agree to Marit, because that's rather an issue of the sample, that those that answered are those that felt confident that they have the competence, and that maybe those that didn't answer are those that felt that they would look not so well. So, but on the other question, the general perception of expertise, I don't need to say that as the EDPS, because at the International Conference of Data Protection and Privacy Commissioners 2006, the DPAs adopted the London Declaration, where basically all DPAs worldwide said that we, the DPAs, have to increase our technical capacity. And I have, since I'm in this function, talked to other DPAs and seen how they have implemented this. And I mean, it has increased tremendously between 2006 and now, and also in the 4 years that I'm in the business, I've seen the number of IT experts and the general level of IT expertise growing in all DPAs that we are in contact with.
Thank you. Let me turn to the audience. In your opinion, is the technical expertise of European DPAs in general today is adequate for the challenges of today and the foreseeable future? 1, yes. 2, no. Who votes for yes? Yes. Who votes for no? An overwhelming majority. Okay, we take this response and we will discuss it further. Now, a second set of questions. We ask the proportion of the people who have some understandings or significant familiarity with new information technologies within the DPA's non-technical staff, because we didn't want to ask the IT expertise of the IT people. Of course, it wouldn't make sense. But the regulatory, management, investigatory staff, the proportion of people who understand technology. And each DPA is represented by a black dot. Of course, we don't reveal the identity of the DPAs. That was a precondition. And we combined this data with the size of the DPAs. So on the horizontal scale, the x-axis, you can see the size of the DPAs. On the left side, you can see the smallest DPA consisting of 1 member. In the middle, the tenths, and on the right side is the largest DPAs. And you can see the 4 categories we offered them. 0 to 10% of their non-technical staff has familiarity or knowledge about new ICT. 11 to 25, 26 to 50, and over 50. And what you see on this slide, there's no clear correlation between the size and the expertise. So you can see very small DPAs with low and high proportion of experts, and the same is with the other categories. So it's not the size that counts, as we know it from other contexts already, but if not the size, what counts? That's the question. So we ask them whether they are satisfied with the existing proportion of expertise. And you can see the green dots means those who are satisfied, the red dots who are not satisfied. And again, no real clear correlation, except for the lowest category. Nobody was satisfied with the 0 to 10% expertise, but in the other categories, you can see, and I tried this, yes, you can see the two DPAs who indicated the highest level of highest category of expertise, but still they are not satisfied with this. All right, so the last slide in this row is, if it's not sufficient, what are the causes of the shortfall? We offer 3 possible answers: difficult to find qualified staff, budget limitation, and some others, and you can see the other replies. For example, low public sector salaries for IT people, lower than in the private sector. So the questions. I will not read the question. You all know, and you can all read it. Amandine, for example, you are working for a large DPA. Everybody has budgetary limitations. But first, what is your opinion about the role of the budget limitations in having expertise? And second, what would you suggest to smaller DPAs, really small DPAs, how to develop or import or have expertise in modern information technologies?
I think I have a common answer for both. I think it's a question of political will. If you want it, you can do it because you can make the decision that will imply to use the budget to do it. 10 years ago at CNIL, even if we were already large, we had no IT experts, none of it. And today we are 10 IT experts and 3 people specialized in foresight. So I think it's a question of what we want to do, and if they want to do it, then they can become, you begin small, and one by one, then you will end up like us.
And what's your opinion on the existing expertise in other, if you know, other DPAs situations, small ones? The CNIL is in a relatively good position in that sense.
Yeah, we are at a good position. I think it's dependent on the DPA. Some of them have some good people, some of them don't have internally the resource to do it. But as we are we are working together, then we can help each other. So I think in the future it will be better.
So far we heard only optimistic judgments. Joan, you spent long years as a vice president of the Dutch DPA, and you were a pioneer of developing privacy-enhancing technology expertise inside the DPA. Now you are an external expert. So how do you see the situation today?
Of course, I have to speak about the past, although I have still a lot of contacts and get some impressions. When I joined the DPA in 1994, in the beginning, there was nothing. There were lawyers, and there was a budget for lawyers, but there was no budget for technicians. We did something different. I came from the industry. I worked for Xerox, and in Xerox we had the technique of using a SWOT analysis, so strengths, weakness, opportunities, and threats. And we also made scenarios. So when I came in, I introduced this. This was a big culture shock. But the SWOT showed very clearly that we were only strong in the legal field. But all the other areas was absolutely nil. So the SWOT also showed that only going for handling complaints was not the best way to do it, to promote a better privacy climate. So on the one hand, you should go for promoting more compliance, and on the other hand, you should try to find remedies. Now,
And
of course,
how do you find the situation today?
now,
Has it changed?
Well, let me say
Okay.
one thing. What we did is that we had an enormous budgetary shortfall, and we created strategic alliances with scientific institutes. So in Holland you have the Applied Science Institute, and you have, for example, the Institute for Mathematics. And we both contacted them, and they were, surprisingly, they were willing to spend their research money on our cause. So we had only 70,000 guilders, which is the half in euros, to develop, for example, the PETS report. And my feeling is that situation hasn't changed at all. Still, there's an enormous budgetary shortfall on the technical side. And the reason for that is that if your vision and mission of your organization is not trying to solve the privacy problem, but only being not proactive but reactive, waiting for complaints, then you will never solve this problem. So there is no strong business case for the government to give you money to create a bigger budget, and that hasn't changed yet.
Okay, the next issue is which solution is better, according to the opinion of the DPAs, to develop their own expertise in-house or to import it from external sources. So as you see, the great majority of the DPAs voted for developing their own expertise. The reasons can be seen here: independence, budget things, and we also ask the reasons of those who opted for the import. One of the commissioners said that the external experts are always better. They are more up-to-date, they have high level of expertise, and that's why they opt for importing it. But the majority voted for the internal developing. So the questions. I will not read it again, but maybe Achim could say a few words. In your case, it was quite easy for the EDPS. They simply imported you, and now the expertise is in-house. But otherwise, how would you judge this situation? What is better? Both are important, both are necessary, but as a strategy, what would you suggest?
Well, the point is always that when you want to buy something, whether it's goods or services or knowledge, you have to need to know what you want to buy to understand the market. So if you have no one with IT expertise in your organization, you don't know how to approach the market to get what you want, because then you are in the hands of the suppliers and you have to believe them. So there's no way to survive without any expertise in the field to which you have access yourself. On the other hand, of course, you cannot cover everything all the time with internal resources. There are peaks, there are big projects which require a higher workload, a higher workforce, bigger workforce than you can reasonably afford within the organization. So you have to find a balance, and that very much also depends on the situation of the respective organization, how much you have in terms of budget for acquiring services, and how much you can actually build up your own internal competence.
John, now you are an external expert, but before you were an internal expert. Now in your position, are you still in favor of developing the expertise in-house, or you would now propagate the importing of external expertise, because it could be a business for you in a good sense? So how do you see it now?
It is, my view is that at least you need some experts in the DPA, but they should be really good experts. And why you need these experts is because you have to understand the business, and you have to put forward the right questions. In fact, what Achim also said, if you don't know your business, you can't put forward the right questions. What I noticed, ideally, I would say that the composition of the DPA should change considerably. There's only one, there are two DPAs where you have seen this. The one is in Schleswig-Holstein, where we had a very close relationship at that time, where they really believed in investing a lot of time and money in technicians and in technical research, because that was also a requirement. You have to be active as a DPA themselves in research. So step into the research, because you learn a lot about this. But if there is no budget, then I would go for a limited number of computer scientists, maybe 3 or 4, and be creative in the salaries, because we had the same problem. And in the end, we were able to hire a system engineer from ICL, who guided us through the first hospital information system, according to Pat's problems. And we couldn't offer a company car. We couldn't offer his salary, so we lured him in the fact that he could contribute to society. But what we did was in the government you have different functions. So he got the highest function possible in his capacity, and you had in the function you have steps, 12 steps, I think, to go to the top of the salary level. And we put him so in the highest position and on the highest level of the salary, and that made it possible to hire him.
Let's ask the audience. What do you think is a better solution, if the DPAs develop expertise in-house, or they need only legal knowledge? DPAs should remain with law and import expertise from outside if necessary. Who votes for option 1? Yes, thank you. Who votes for option 2? I don't see any hands, so 1. Okay, thank you. Now, another nice scattered graph to see whether they use at all the expertise in the DPAs in their investigations. DPAs are routinely conduct investigations on complaints ex officio, and we ask them that in their estimate about what percentage of their investigations involve any kind of ICT aspects, telephone, mobile, internet use, email, and things like that. And you can see again that the picture is really varied. The highest number was indicated twice, here on the right. 2 DPAs said every investigation involves some or another kind of ICT aspects. And the lowest score is 2, somewhere down. Countries and investigations are different, but still it looks like a bit underestimated. Well, and the next question was, to make it more appealing, the graph, what percentage of the investigations required specific ICT expertise? As you can expect, this cloud is a bit lower to the scale, but still one of the two DPAs who indicated that 100% of the investigations involve some or other general aspects. This DPA also insisted on that each and every investigation requires specific ICT expertise. These are the 2 extremes. I connected with lines those 2 points against each DPA has a green and a red dot. And you can see that the difference is sometimes quite significant between the 2 scores. So the question, only one question. Again, Marit, I'm not afraid that the effectiveness of the Schleswig-Holstein Privacy Commissioner's Office is reduced because of the lack of specific ICT expertise. But in general, what is your opinion of other DPAs as you see the European scenario?
Perhaps this is now a question of definition of what is specific ICT expertise. If you go back to the slide, I'm one of the, my answer was one of those who have the most difference between the green and the red sign here, because almost everything involves ICT. There is digital, I know which one.
Okay. Maybe
Yeah, but 10% and 95, yeah, that's my answer. But what is specific ICT? Where do we need also help? What about specific K-anonymity questions? What about cryptography? Can we check that? What about forensics? We have a person who is specialized on that. That's very rare. But what about IP addresses? What about privacy policies? What about something where it's a database? Not already perhaps big data, but something where, of course, there's some electronic data ICT system. And so for me, specific ICT is something where we have very few people. Perhaps others have answered in a different way. So this is now a problem. The lack of very specific expertise, as like my colleagues have said already, we cannot have for each case or each potential case the specific person, the specific skills already in-house with a limited number of employees. But of course it should be, and perhaps this is now a question or an idea for everybody, have a center where DPAs can share this knowledge, like a pool of this knowledge, that people can hire a person from Schleswig-Holstein for 1 month that is specialized in one topic, and we would like to have input from others who have this specific expertise, because I think one thing we haven't discussed yet is the difference of culture in arguing and discussing and in reasoning. And also ICT people, and I'm one myself, may have difficulties in this legal and administrative domain, where it's sometimes not only because of the salary, but also because of the way of discussing, may be highly unattractive to go into such an organization. And this means that if we have specialized ICT people somewhere in the European Union, why not using the skills in a better way? This must not, of course, affect independence, but I think there might be some possibilities that not each, and which is not possible, each DPA has to build up everything on their own, but also that not everybody is dependent of external resources. And therefore I think here, of course, if nobody in Europe can solve some problems, we simply don't understand big data, for example, or we simply cannot handle that, then this would be really bad. But if we find a way to be more efficient, effective, and people who are already used to think also in legal terms and in fundamental rights, that this can be already an experienced process, this might be a solution.
Achim?
Yeah. I'd just add to, it's actually the last point that Marit mentioned. There is a specific ICT expertise that the DPAs needed, and that is IT experts who understand data protection and the legal framework. I mean, we cannot just take the world's best cloud computing architect. He won't be able to help us because he doesn't understand our questions. And that is the unique experience that we have to build up in the DPAs. I'm lucky that in my team everybody has, apart from the core ICT knowledge, another relevant background in security and auditing, in data protection issues. But that's actually what's needed. We don't need the fresh university graduate who has never looked beyond the core IT matters.
Amandine, you really have a specific expertise. She's a cryptography expert in CNIL. How do you use your expertise? How CNIL is using your expertise in their work?
I think first they learned me privacy risk management. So I think I'm using my cryptography expertise, 10% of my time, maybe less. I'm teaching my law colleagues some basics in cryptography, or at least what is a hash function and what does it mean, encrypted stuff. When there is very cryptographic technical stuff, I'm the one looking at it. But most of the time, finally, I learn a new expertise in privacy risk management, and I'm using it. Okay. So, in fact, I think we did both external experts in-house. I have been
one of these
hired for my crypto and internal formation, because then I learned a new expertise.
A quick vote. This is maybe a bit provocative. can data controllers, I mean companies, government offices, service providers, can they mislead the DPAs in technological matters? 1, frequently. 2, sometimes. 3, almost never. Who votes for option 1? Yes. 1.5 if I see. Yes. Who votes for 2? Sometimes. Majority. And who votes for number 3? Very optimistic. I must say that the audience seems to be politically very correct, but one can hear more radical views in
I would argue they can do it frequently, but the risk, if it later on,
we were not asking.
If they probably
don't.
It's not an interest of them to do them usually, but they can. I think almost always, if they want, they can.
Okay, ICT is a moving target, as we all know. It's changing very fast. So it's evident that DPAs must keep up with the new developments in ICT. So we asked them how they try to do that in 3 named possibilities: formal training, conferences, and bringing in external expertise, or some other possibilities, and you can read the other answers. Conferences were the most popular in this set. Maybe CPDP has a role in it. The questions, quite a few questions you can try to answer. Whether you find it really the best or one of the best means to keep up with new developments, to go to conferences like CPDP. John, for example, how would you rate CPDP or other conferences, or you would like to emphasize specific, more technical conferences or other means to keep up with fast-changing new technologies?
I think the CPDP conference is a very useful one. I always compare it with the conference of the data commissioners themselves, and this conference is by far much more informative, it's more provocative, and I think for people who really want to know what's going on, this is the right conference. Better than other conferences, that's true. Discussing amongst data commissioners, I know in the past we did, but it was then still in the beginning, and what changed a lot was that we got a WP Article 29 group. In the beginning they were quite slow, but now their opinions are very valuable. So this gives an extra stimulus to understand what's going on in technology. Still, I think they are too reactive. What we discovered in our own organization is that if you want to be proactive, then the organizations themselves should do technology assessments about developments at a horizon of 3 years before it will be introduced in the market, so that DPAs and their staff know what's coming up, and so they can then have the knowledge to talk with companies about new developments. But if you wait until they are there, you are no standing anymore for those companies. But in the past, with our attitude, we had discussions with HP, we had discussions with NCR. We even offered them our expertise when they were testing their machines. So you can become very proactive if you want to offer your expertise and service and a platform of understanding for those companies, because they are really looking for a partner when they are developing their products. And most DPAs are very shy. They think that it's risky to get involved with discussions with companies, and I really believe it's just the contrary. You can be very beneficial if you do that.
Amandine, what's your opinion on this? About the conferences and about getting involved in discussions with companies?
We are participating a little in conference, but mostly we are working either directly with academics, we invite them, we make edition, or we make consultation open to both academics and industry when we have questions that we don't really know how to solve. I don't know if conference is always the solution, because you learn new things, it's right, but to have a true discussion, as in it's a bit short time. So, relating to academics, we had, for example, one project with mobilityx. We built it with INRIA, which is a research group in France, and we had questions about what app on smartphone are doing in a privacy way. They had also question, more research question on that point. So we built a project together and we find a solution. So I think we can, conference is the thing, but having an open discussion with both academics and industry all the time is more, useful in the long term.
Okay, let's switch to the issue of proaction or proactivity. John mentioned it several times. We asked the DPAs whether they prefer participating proactively in ICT-related decision-making, or they prefer waiting and responding when the challenges are clear. The overwhelming majority was in favor of proaction. My personal feeling is that it's rather a sign of wishful thinking, because as I see the work of the DPAs, they are not so proactive, not so overwhelmingly proactive in legislation or in influencing companies' decision-making. Of course, we ask why they prefer one or the other. You can read their answer, and also the few who wanted to wait and respond accordingly. One of the commissioners clearly stated that it's better to act for a commissioner to act only when the challenge is clear. But it was a minority opinion. So the suggested questions can be seen here. So Marit, for example, what's your opinion on proaction, or rather, what is better, to try to influence legislation or try to have an impact on companies' decisions from your perspective?
Okay, so first, to be fair, the question you asked in the survey is, what do you as a DPA regard as more important? Not that they are doing that.
Yes.
So
yes.
I think that's already a good sign, seeing what do they think it's more important. Okay, be proactively there. I think this is it. But then of course, the question is, then it's perhaps, I have to be afraid why have others not answered proactively. So this may be a problem the other way. Okay, and to weigh different ways, it's always very difficult. So for us, and perhaps also for me myself, it's very important to be involved, to know, have first-hand experience, if possible, to influence technology design. But our usual way to be involved, and also as a Schleswig-Holstein DPA, is to handle complaints, very many complaints, which is not about technology design, or perhaps we are asked a few legal questions. Usually we are not even involved in lawmaking. So this is not our task, but if there's some law we can criticize, but even then, very often the answer is, you can do it that way, it would be okay. It's not that we would like it better in another direction. We can have some proposals, but at the end of the day, it's fair enough. And if we say, you have to consider new technologies, there are so many options. And I say, yeah, but this is an option, it's not demanded. There might be now a change with the General Data Protection Regulation, where at the first time, privacy by design is mentioned. Not in a way where I think it's already clear what is being meant, or that it's really something where also lawmakers have to consider that. I can argue why it is the case, but I don't think that anybody can sue, go before a court and saying, you have to change the law because of this General Data Protection Regulation. So this means our daily business is totally different from what is important. And our daily business is defined in our laws. And now there could be like a revival of the data protection laws because of the reform.
In some countries, the privacy commissioners or data protection commissioners have a right to give opinion on draft legislation. Mm-hmm. That could be a tool, but maybe legislation is too slow to follow the technological changes. Yeah. Achim, and before you answer, Could you say a few words also about how the EDPS tries to influence ICT-related decisions if it's not confidential?
No, I mean, that is exactly what I wanted to say. I mean, we try to, I mean, we have to, of course, we have to deal with the cases which come to us. And the question is, where do you draw the line on being proactive? I mean, when we have a prior check for a new IT system, that is day-to-day business, but at the same time, of course, it's proactive because normally this new processing operation and system isn't there yet, and we have the possibility to influence it. That is one of the tasks for all DPAs according to the regulation. It will be the current directive and the regulation. So there is an element of proactiveness that no one can escape. We have, and no one wants. I mean, all DPAs, I think, are doing this as a clear priority. We have the task also to advise the legislator, and we have used this also very often, very clearly, also in the past, and have influenced the design of some of the European information systems by our advice. There were technology experts in the EDPS before I joined, so some of this credit goes to my predecessors. It's quite clearly that these concrete measures where legislation and technology come together in a political decision is a field where we can also do that. And we have the more broader policy initiatives, like when the Commission issued its policies on cloud computing, we had long been in discussion with them to make it clear that they cannot just give a derogation from data protection or saying, oh, we need to develop cloud computing, so we cannot have this blocked by all these old-fashioned data protection laws, but that on the opposite, they committed themselves to respecting these laws. So this is things that we do to our legislators, politicians, political bodies, and the controllers, the organizations that we supervise. But then since 2013, early 2014, we also try to work with the IT, technology development organizations directly. That was in the half year after the Snowden revelations. There was the IETF meeting in Vancouver, where the participants agreed that mass surveillance should be treated as an attack like any other technical attack, and it should be accounted in the design. And we took that as a sign of the willingness of the IT developers to do something about privacy. And then we launched a call for interest and talked to people and so on. And at the end, what we found, what came out of that is the Internet Privacy Engineering Network, IPEN, which had its first conference in autumn 2014. We had another conference next year, and this year we will continue with our partners, including Schleswig-Holstein, CNIL, and some others who are here in the conference and in the room, not only DPAs, but also civil society, academics, the IETF and others, to kind of bring this into practice. I mean, one big challenge for the next 2 years is the GDPR has a lot of provisions on privacy-enhancing technical elements, not only privacy by design, data protection by design, but in many other provisions there are elements which lead to certain technical requirements. And to translate these legal obligations into engineering terminology and engineering requirements is one of the tasks it's a main task or a major task for the next 2 years.
I think this is a very good practice, maybe a best practice, because in some countries still exists a way of doing legislation. When the legislation is drafted and adopted, the systems are already there. So it's just a kind of legitimation of the existing system. But this way, what you mentioned, to work together with those developers or those system designers who are willing to cooperate with the DPAs, that's a good solution. But let's take a quick vote for the audience. What would be better, in your opinion, for the data controllers, so the companies and the government offices, if DPAs were proactive and could have a say in decisions before the decisions are made, or they waited until the situation is clear and responded accordingly. Who votes for option 1? Proaction. Quite popular. Thank you. Who prefers option 2? A minority. Okay. So that's, you almost replicated the opinion of the commissioners themselves. But let's switch to the last, the 7th issue. Don't worry, you don't need to read all the words, and I won't read it either. But these are the real responses of the DPAs, and it was a great surprise for me, at least. There's no consensus about them. The question was about what are the most relevant technologies of today and tomorrow which have privacy implications. And you can say that there's really no consensus. Altogether, 68 separate technologies, applications, uses were mentioned, the great majority of which were risks, so to say, and only a few were solutions. And in average, one technology was mentioned only twice by 33 DPAs who responded to this question. In average, 3.5 technologies were mentioned by DPAs. Of course, there were some favorite or popular hits like big data or Internet of Things, but the rest is a mess. So anyway, we needed to squeeze these responses into digestible categories. And you can see that the smart environments, the technologies which could be called smart technologies, were mentioned the most. Surveillance, mobile tracking, a bit less. And I'm very happy to see that the solutions were not the last in this row. So the questions. What are the most difficult technologies, in your opinion, and especially, Marit, for example, in your organization, what was the most difficult technology to deal with, or will be, maybe, in the foreseeable future?
Again, if we see only complaints, then Schleswig-Holstein is not in the forefront of technology development, I think. So now we were, for example, asked about drones. Are there any complaints? And there were no complaints. We discussed that with journalists. They published that, and now we have complaints. So now we know that there are drones flying and can do something about it, because now people are aware of there might be a privacy problem. Drones are one of the problems. I've seen that. It was not in my list, because it's not one strategic new thing. And I had the idea that it is a consensus of everything. If you go to a computer exhibition, you see all the buzzwords. So these are the future technologies, and so they are very important, and they will come. And of course, not everybody thinks now about biometrics the same as of big data and so on. But so this will be the most difficult technologies will be those where the law probably has no real answer, where it's not solved in the general data protection regulation, where we are still not on the same level in arguing, where we know that there are deficiencies, which have been discussed here for the last years, but where there's no real solution. This may be big data, there may be other things with mass surveillance, but perhaps there's a solution next week with Safe Harbor 2.0 or so. No, but we see that there's so many ongoing debates also about is consent still okay for people? Is it about purposes which we have to make it as a stronger concept? And therefore we consider more the ways of solving problems as most interesting ones, most influential ones. At least they should be more influential, and therefore I am happy that I wasn't the only one giving some solution ideas, but obviously others have answered in that way as well. Because right now I see a totally different thing here. What is really the risk? That those technologies that are used by the masses of the developer companies, when you set up a website, for example, that they are really not privacy compliant. So those people who want to do the right thing, who have learned to be a programmer, they take libraries, they put together many things that is not about prior checking. It's not about where they have the feeling that there's a big risk. It's only taking from what is there. And right now the standard is crap. And this means if we cannot influence these general technology libraries, building blocks, then I think we have lost in a major field. It may not be always the high-risk part, but the high-risk people usually come to us on their own motivation because they don't want to have a bad reputation if something goes wrong. So this may be the highest risk, but here we have mechanisms. I think with the lower risk data processing, which means sipping into every area of lives, this may be the real high-risk thing.
It seems that this kind of fragmented attention of the European data protection authorities somehow distracts their focus points, but Achim doesn't agree with this.
I couldn't disagree more. Firstly, there's a lot of coordination. I mean, there is a sequence of paying attention to emerging discussions in the cooperation of data protection authorities. Our deputy supervisor, Wojciech Wibrowski, put it like that once, saying, well, the Berlin group, the International Working Group on Data Protection and Telecommunications, normally the first one to discuss these matters, and they come up with very interesting early positions on that. And then individual DPAs look deeper, but then the next level often is that the Article 29 Working Party gives guidance on these matters, and that is then put into practice in anything. I think a problem with your slide and your assessment is that there is issues in terminology, that different words are used to describe similar or related matters. When there's IoT, Internet of Things, smart homes, smart environments, basically sensors, that's all the same. I mean, it's all elements of the same discussion. And that's also when, because we're working in Brussels, one of the European centers of lobbying, the first part on the work is always to get the lobby icing of the technical statements. I mean, many of the buzzwords used in the political debate have no clear relationship, no clear translation in technical terms. It's just the political wrapping around some technical issues, and unfortunately you have to respond in the terminology of this political wrapping, because otherwise the politicians won't know what you're talking about. But the technical questions are not really presented and discussed, and so that's a two-viewpoint approach. And then also you have to talk about, I mean, the political discussion on cloud computing at EU level started like 6-7 years ago. And if you think of like the provisioning models and so on that were seen in this model at the time, and what we actually do have on the market, and what we actually do see in procurement by the public sector, now we have a completely different way of procuring and using cloud computing in the market. So, and this buzzword model just doesn't work when you do it in practice, and so that is also putting a bit in perspective the apparent fragmentation.
Before inviting the audience and our special guests to intervene, may I add one more question which is not listed here. The first vote of the audience, if you still remember, was about the existing expertise of the DPAs, whether it's sufficient or not, and the majority voted for not sufficient. And how can it be measured at all? And who would be measuring this? An independent body or the new European Data Protection Board to be established under the new regulation? Or how can it be somehow evaluated in a more unified European data protection scenery? Who would try to have an answer?
Try and be brief.
I only want to, I was worried about what I saw on the questionnaire. How can you measure yourself if you have no benchmark? So the minimum we should get is a skill benchmark, as companies do themselves, and they compare with other companies. So this could be a good task for maybe EDPS or another group that is representing all the data protection authorities, and building up a skill-based benchmark, and also I think that self-assessment itself will not work. because that is biased, and from a psychological point of view, it's only subjective. And as there is no obligation to fulfill what you have self-assessed, there's no pressure really to give the right answers.
Okay. Now, before giving the floor to the audience, I give back the floor to Charles to introduce our guest. That will be the...
Thank you very much. I think this is, so far, has been a very rich set of responses, and I think that people were, I suppose, letting their hair down and talking about what happens in their own organizations as well as generally, and that's really good. But we'd like to hear from the audience about their thoughts on what they've heard, what they've seen in the slides and so forth. But before going generally to the audience, HP was, I think, the only company that was mentioned in any of the responses, and we do have Daniel Pradel from HP in the front row, and I'd like to ask him to spend 2 or 3 minutes or so giving his responses and his contribution.
Thank you, Charles. And let me introduce myself. I'm Daniel Pradel. I'm the Global Director for Strategic Initiatives and External Relationship for HPE. I'm a member of the Privacy Office of Hewlett-Packard Enterprise. The first point, I would like to thank the panel for all this discussion and the opportunity for me to present a view. The first point I would like to mention is on the level of expertise, which level is appropriate, and in particular for new cutting-edge technologies. Knowing the limited resources available, it has been mentioned, and also the accelerating speed of technology, it will be a serious challenge to maintain this level of expertise, keep it up to date, and highly efficient. The second point is about the type of expertise. Technology was mentioned several times, but these days it's often more than technology, and technology and business practices are very often embedded together, difficult to separate. Then it's not technology stricto sensus. It's also about new practices, new business models, which are sometimes complex and evolving. Third point, and in particular with the concept of accountability, it's now essential to change paradigm and to develop and maintain a closer collaboration. It has been mentioned by John Borking, and maintain an ongoing dialogue between the DPAs and the business and the industry. Business can provide deep knowledge on today and tomorrow technologies and practices and the trends. And it will be done in a way which will be efficient and up to date in terms of knowledge. The fourth point, the GDPR introduced the concept of one-stop shop with a lead DPA, which will have a sort of privileged relationship with a large company. But unfortunately, it's often described as the institution to handle complex compliance case, issue opinions, and do arbitration, when there are different interpretations of the law, which is true. But I think that this lead DPA, with the extended knowledge of a large corporation, will have the opportunity to better understand what's going on, to have this dialogue with a large company, and to gather up-to-date knowledge about what's going on and what will be introduced soon in the next month or years. Why not using this privileged relationship to understand the current and emerging technologies? In summary, I think it's time now to consider that there is an opportunity for what I call a trustful, forward-looking dialogue and collaboration between the technology and data protection authorities. This collaboration should cover several areas, such as advanced regulatory framework, responsible governance for a company, I mentioned accountability, and also indeed technologies. And especially I liked the idea of Mrs. Hansen to have this center of knowledge, European center of knowledge or global center of knowledge, I don't know. But why not having a participation of industry experts in this sort of center of knowledge.
Thank you very much, Daniel. There are a number of suggestions, very interesting, I think. I don't think we have time to address all of them, but would any of the panel like to pick up one or two and maybe leave the rest for private conversation?
If I may suggest Marit could respond to these suggestions by Daniel.
Thank you very much also for mentioning my idea of pooling some expertise. I'm a little bit afraid that especially those one-stop shop DPAs, which are not the biggest ones sometimes, and probably, I'm not sure whether they have answered, we can see, well, at least that there may be not so much skills in all areas that may be affected, because it's not about one industry, it may be about several totally different models, and I totally agree with it's not only about technology, it's about practices, business models, the equal playing field, something within Europe, perhaps even a globalized playing field that we have to take into account all these argumentation, but not necessarily buy it, not necessarily take it as it is, but that we may demand changes, saying the equal playing field may be different from what we have already now, which seems to be accepted, that the internet is for free, that the advertising is the business model we have to go for. So I don't have to accept that. I may have to accept realities, and it's difficult what to demand, and of course we need alternatives. But only having an open mind, I think this would be very nice. So if we go for the industry participation, we need also the consumer rights participation, all rights, fundamental rights organizations, some other voices, also not the big industry, also SMEs, and this would mean probably a 100 people board, which is much too big. So we might have a DPA board at first. Perhaps this can be some extension of the European Data Protection Board, where we have the skills and the debates and also personal exchange. And then we will have to see who are the people giving input, to which meetings is whom invited. But of course not blocking out industry. But at the same time, industry is one of the players. We need to understand their motivation. They have a specific motivation. Fundamental rights is not on the top of the list, and it has to be that way. I fully understand. But of course, we have different incentives, different motivations. So if we, therefore, I think we can, you have nodded, so that's very nice. We can argue that this has to be one option, but it could not be the case that industry with much larger personnel in the big areas can then dominate the one-stop shop DPAs. So this is a risk, and probably you didn't mean it that way, but therefore we need some other balancing issues to keep the independence of the DPAs.
Before giving the floor to Charles for his concluding remarks, maybe John, very short, yes, because we would like to open the floor to questions. And
the suggestion that was given to get more liaison with the industry was picked up by the CEN. In 2009, the CEN issued a management standard where they created, in this management standard, the idea was to create a platform where the industry and the DPAs can come together, or experts in the privacy field, and companies can ask for guidance in the early development of their products on a confidential basis. Mm-hmm. And this was accepted by the industry. It was a viable idea, but the lack of budget made it impossible to create this kind of institute. But this would be an institute that has an early warning system, so that also DPAs know this kind of technology is coming up. The idea is 3 years at least before introduction in the market. You have to know what's going on.
30 seconds.
Thank you.
30 seconds. I mean, at EU level, there are these talking groups and coordination groups organized by the Commission on technologies, on cloud computing industry groups, on smart cars, everything. And DPAs participate in this dialogue. They talk to industry directly. And I mean, there are people from intelligent transport here in the room who could respond on what we have been doing there, together with national DPAs like CNIL involved there. And the other thing is, of course, what we do in IPEN is also open to industry to pick up, so they're not excluded. Thank you.
So now the floor is open to questions
Okay.
and comments from the audience.
Could you, yeah, it's hard to see from here, so wave your hand. There's a question here in that row.
And I would like to single out one issue which actually Marit just mentions about the integration. And we said that the technology expertise is a mess, as you say, because ICT is a mess because it's evolving, okay? But she said one thing that is important is you need to integrate things coming from others, from suppliers. And the suppliers might have taken decisions that you have to cope with, and then you want to do good, you want to be privacy friendly, but actually what you take is not good, okay? So the expertise that I like to see is the expertise on integration. What would be the guidelines you provide to suppliers so that they get into the virtuous integration ecosystems? So my question to you is, shouldn't we work on that? And should IPEN work on those things?
Short
Shall we
response?
collect some more questions from the audience? Questions, comments? Julien? And next, the gentleman sitting there.
I was really interested in the survey because I think it's starting, although there are some methodologic questions that were also partly addressed, but I think it starts tackling this question of the mediation between legal expertise and IT expertise. I have a question, well, first of all, regarding whether or not this is going to be an ongoing research project. So it's the first step of a research project, or what the perspective is. The other thing is there has been some questions and some talk about cooperation with the industry, but I have a question which regards data protection officers, whether or not, because in some countries, and especially countries that are from the DPAs that are represented here, data protection officers are supposed, at least when we read the text and probably also in practice, do this mediation. Yeah, so my question, briefly.
4 minutes.
Is, are they also going to be studied? And what the impressions are from members of the panels of IT expertise among DPOs and how they participate in this flow of information and expertise between DPAs and the industry? Thank you.
Third question. There.
Excuse me, one word to the sound managers. Can you reduce the echo? When we have the room microphone, it's so much echo that it's very difficult to understand.
Okay, so this should be better. Simon Ania, I'm with TomTom. We're in the space of wearables and automated driving. So I'm currently busy with stuff that hits the road 3 years from now, and Achim referred to that. I do want to make a comment on DPAs wanting to be more involved with technology going forward, and in the question it almost seems like it should be mandatory. Now, do be aware that we are also challenged by making privacy a unique selling point. If you want to make privacy a unique selling point and embed it in technology, you better be careful with what you disclose because your competitor may run to the market sooner than you. That's one. The second is that it also becomes highly relevant to start patenting privacy-enhancing technologies, which in itself actually provides value to the company. Nevertheless,
could you be?
Yeah, I cannot be. Now the question is, yes, I would like the panel to reflect on that, how to do that balance, and at the same time, I do offer anyone in the room, academia or any DPA in Europe, the opportunity to invite me for a technology update. I've done that with the Dutch DPA, worked very well. We can do that. We can make it happen.
Okay.
Thank you. Could you respond very briefly? One question was addressed to Marit, then about DPOs, and the third question.
We only have about one.
Okay,
1
expertise
minute.
and integration, very important, and also the point, pets, to use pets, integrate pets, may not automatically yield a good result, and but there's much work in progress, and it has to be. It's an open research question. We both know that. So we have to invest there more to have really building blocks with real interfaces, and I hope that we can go along. With the DPOs, as a German, I'm a big fan of DPOs, and because they are saving so much work, so they're really the competent authorities in their business organizations or in the administratives. And we have an own teaching program, because one person cannot, usually it's only one, cannot deal with all the topics on an equal level of expertise, but also how to integrate, how to involve other expertises, for example, how to deal with the security officer in the company, because it's good to have these both roles within different heads, that they communicate because of different incentives, different motivation. But we believe it's a really good concept, and even if it's not mandatory, it should be optional, that people can do that, and also for business we see it as a good solution.
We don't have time more. We can continue the discussion during the coffee break. I give back the floor to the chairman.
I just have one final question to put to the audience. Ivan and I are thinking perhaps of writing up this survey and bringing into consideration what the panel is talking about. How many of you think it would be a good idea for us to go ahead and try and publish something on the basis of this? The second choice is that it's not a good idea. The third question is maybe. Who thinks it's a good idea for us to try and do this? I'm glad you said that. Who thinks it's a bad idea? Who thinks maybe? Okay, there are a few maybes. Thank you very much. It remains for me to thank the audience for coming and listening and contributing, and also to thank the panel very much for sharing their thoughts with us and for responding so well to what we've put before them. So thank you all very much.
Thank you very much. Now coffee break.